Are, are we ready, Trisha? You're
Yes, we are.
All right. Good morning, everybody. Welcome to the California Board of Occupational Therapy Board meeting. Today is June 13th, 2025, and it's 9:35 a.m. Can we please establish a quorum?
Yes. Board Member Hector Cabrera,
Present.
Secretary Richard Bookwalter, I'm present. Vice President Christine Wheatless-Bach,
Here.
President Beata Morcos.
Here. We have a quorum. Agenda item 16, President remarks. I don't really have any remarks. I just would like to welcome everybody in the audience. You'll have a chance to introduce yourself. I'd like to thank DCA for hosting us here. We love being here with this very professional setting. And that would conclude my remarks. And 17 is board member remarks, informational only, no board action to be taken.
I have no remarks this morning.
Christine, Hector?
No remarks right now.
Great, thank you so much. And number 18 is public comment for items not on the agenda. This is your time to introduce yourself as well and have any comments, public comments. Can go ahead.
Hi, good morning. Sammy Rafidi, President of the Occupational Therapy Association of California.
Welcome. Thanks for nice to see you.
Great to see you. Thanks for having us.
Good morning, Ada Boone Hurl, Program Director, Sacramento City College OT Assistant Program. A true pleasure to be here. Thank you.
Thank you for being here. Welcome back.
Hi, my name is Yuritsa Rodriguez, and I'm an OTA student from Sacramento City College.
Awesome, welcome. All righty, so we don't have any other public that would like to introduce themselves here. So could we please, what? You know how I like my microphone. Can we please go to open up on the WebEx, Trisha?
Thank you, Madam President. If any member of the public logged into WebEx would like to comment, please raise your hand. We'll give you a moment. All right, I'm not seeing any raised hands, so Madam President, I return the floor back to you.
Thank you so much, Trisha. All righty. Agenda number 19, presentation from the Department of Consumer Affairs Budget's Office. Do we have Matt with us or? Oh, so I'm sorry, Suzanne. My apologies.
This is the moderator. We do have Suzanne with us. She is muted. So Suzanne, let's see if you can unmute yourself.
Yes, hello.
We can hear
Kayla,
you.
yes, Kayla is going to be presenting.
So this is the moderator, Kayla. If you want to unmute yourself.
Yes, good morning. Are you able to hear me?
Yes, good morning.
Okay, perfect. I'll go ahead with the presentation now. First of all, I'd like to say good morning. My name is Kayla Van Lint, and I'm a budget analyst with the DCA Budget Office. And I am joined by the budget manager, Suzanne Balkis. I want to thank the board and executive staff for allowing me to present today. We would like to provide some information on the budget office's roles and functions. At the budget office, our main role is to facilitate the annual budget process for the department for all of our boards and bureaus. Another role the budget office provides is support and guidance on monthly projections to assist the board executive staff in making sound decisions on both annual expenditures to their appropriation, as well as maintaining a structural fund balance. A few other functions of the budget office include assisting the board by coordinating legislative bill analysis and regulation package development services, facilitating communication and coordination of information between the board and state and legislative control agencies, and providing various consulting services, including fee analysis, regulation review, BCP review, and assistance on schedules, including out-of-state travel. Those services are specific to the budget office. However, DCA provides a wide range of centralized administrative services to all boards and bureaus through its two primary divisions. The first is Consumer and Client Services Division, which includes human resources, facilities, budgets, contracts, accounting, training, outreach, call center support, and legal services. And the second is Division of Investigation, who provide enforcement services. DCA provides these services to the board by utilizing funds obtained through pro rata, so the board doesn't require its own staff for these services. The cost for these centralized services are distributed amongst all boards and bureaus utilizing various distribution methodologies, which are based primarily on authorized positions. For example, the greater number of positions would essentially require more admin support, such as HR-related workload and costs. And participation rates, for example, call volume, where more complaint calls received by the call center, or IT usage, the more licensees applying for licensure or renewing drive higher costs, or DOI, enforcement investigation activity, where the more cases sent to DOI drives higher cost enforcement related cost. Now, if you would please refer to agenda item 19, the board's expenditure and revenue projections and fund condition statement. I'm first going to start with the board's expenditure, which is the second page of your materials. Projections are based on actual data through fiscal month 10. This report includes 2023 through 2024 actual expenditures in green, as well as 2024 through 2025 budgeted and projected expenditures in blue and orange. Looking at the totals at the bottom of the document, you will see the board has a beginning base budget of $3.3 million and is projected to spend about $3.3 million, creating a reversion to the board's fund of approximately $400, a reversion percentage of about 0.01%. The next document I will review is the board revenue projections, which is the first page of your materials. This report includes receipts collected through April and projected revenue to year end. I will go further into these projections as we transition to the next page of materials. The third document of your materials is the board's fund condition statement. As a reminder, we read this document from top to bottom and left to right. The left column is the board's prior year, 2023 to 2024 actuals. It shows the board began 2023 through 2024 with a beginning balance of $1.489 million. The board collected $3.173 million in revenues, with $466,000 from initial license fees, $2.497 million from license renewals, and $210,000 from the issuance of citations, fines, delinquent fees, and other revenue. The board expended $3.157 million, which includes $282,000 in direct draws to the fund for statewide pro rata and pension payments. The board ended 2023 through 2024 with $1.50 million reserve balance, or about 5.1 months in reserve. The current year, 2025, the board projects revenues of $3.325 million, with $422,000 projected from initial license fees, $2.682 million from renewal license fees, and $221,000 from the issuance of citations, fines, delinquent fees, and other revenue. The board's 2024 through 2025 total expenditures are based on the revised governor's budget, with fiscal month 10 projections at about $3.525 million between authorized expenditures and direct draws to the fund, leaving the board with a fund balance of approximately $1.305 million or 4.6 months in reserve. A few things to note about the board's fund condition. The fund condition is a snapshot in time. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases, as well as employee compensation and retirement rate adjustments. The budget office includes a conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You will also notice that most revenues are projected static in the out years. Lastly, I would like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would create cost pressure on the fund. The budget office will continue to monitor the board's fund condition statement and keep the line of communication with the board's executive staff open for any future needs or expectations. Again, thank you for allowing me to present at today's meeting, and I will now be happy to answer any questions.
Thank you so much, Kayla, for your presentation. Do any board members have questions? How about the ones on WebEx?
Thank you so much. If any member of the public logged into the meeting would like to ask a question, please raise your hand. We'll give you a moment. All right, I see no raised hands. So Madam Board President, I return the floor back to you.
Thank you so much. So, what do we? Oh, okay. All righty. Do we have any public comments here in the audience? Just to verify. Perfect.
Thank you.
All right. Thank you so much.
Thank you.
We're going to move on to agenda number 20, consideration and possible action to initiate the rulemaking package to amend California Code of Regulations, Title 16, Division 39, Article 4, Section 4130, fees. So,
were we able to get microphone access for Matt?
Yes, can you hear me? This is Matt Nishamini.
Hi, Matt. Yeah, we can hear you. Did you want to begin, or do you want me to introduce the materials? It's up to you.
Actually, I'm going to kick it over to my colleague, Sam Dyer.
Sure.
I can start, Austin.
Thanks, Sam.
All right. Good morning, board members. I'm Sam Dyer with the DCA Budget Office. I'm here with Matt Nishamini, Fiscal and Regulatory Specialist from the DCA Budget Office as well. I'm just going to be walking through the license renewal workload and fund condition scenarios for a fee increase as proposed. So the proposed language raises biennial renewal fees for occupational therapists from $270 to $300, and biennial renewal fees for occupational therapy assistants from $210 to $240. The first chart in agenda item 20 shows the board's workload cost of processing one license renewal, including an enforcement rate or enforcement cost allocation. The board finds that its cost is $312, exceeding their statutory fee cap of $300. The next attachment is a statement of the board's fund condition as is, so without any changes to the fee structure. Here we see a structural imbalance where expenditures exceed revenues continued into future years. At the bottom, you'll see a row called months in reserve. Without any fee change, the board's fund is projected to reduce from its current 4 months in reserve and go negative in 2029. The subsequent attachment shows the board's fund condition with the fee increase as proposed, OTs at 300 and OTAs at 240. The revenue generated at these fee levels does not eliminate a structural imbalance, but it keeps the board's fund afloat, even though it runs a thin reserve. In this scenario, the fee for OTs is at its statutory cap, but the OTA fee is not. The board would still have room to bump its OTA fee if desired. The traditional way to raise a program's statutory fee cap is through their legislative sunset review, and this board's sunset is scheduled for 2026. In a situation like this, with a structural imbalance, low months in reserve, and fees at their caps, we typically see a statutory change in fee caps to give the fund some wiggle room. However, and this leads me to the next fund condition scenario, fees would have to be at their caps to show the legislature that the board is doing all they can to combat the structural imbalance. So in the third scenario, OT and OTA renewal fees are both at the caps of $300. You would see a bump in reserves upon implementation, but ultimately would not eliminate a structural imbalance in out years. This scenario gives the board flexibility to up their limits in sunset, which wouldn't increase actual fee levels for the licensees until the board takes regulatory action to change the fee levels. So again, it just provides flexibility. There are policy considerations to be made, of course. In the earlier scenario with OTAs at $240, the board would be raising fees for both OTs and OTAs by the same amount, $30. And this would be keeping OTA fees lower than the OT fees. This may be a decision by the board to keep a lower barrier to entry into the profession. But this scenario would also make a sunset fee increase less likely than if both fees were at their caps. Thank you for your attention to this matter. Matt and I are here to answer any questions.
Thank you, Sam. Have any questions from the board members?
Not towards Matt. Christine, Hector, do you guys have any questions for Sam?
Not right now.
I'm sure I will. I'm not, to be quite honest, I'm not quite sure I understand.
Okay.
So I could maybe give a recap or a summary.
That'd be
It
awesome.
might be
Thank
beneficial. So
you. Yeah.
what we're looking at here, following the fund conditions that Sam just went over, we have proposed language to increase the renewal fees for OTs and OTAs through regulation. Right now, the cap, the maximum we're allowed for either of those by statute is $300 per biennial renewal. So traditionally, or historically at least, there has been a difference in the renewal cost for OTs and OTAs. It's been less for OTAs. So we have the option to approve a regs package to increase them both by the same amount and keep that difference so that OTAs are still lower. Or we can approve a regs package to go forward that would bring both renewal fees to the statutory cap of 300. And there's pros and cons to either one, meaning that when we go for our sunset review, because ultimately we need to increase the statutory cap. So when we go for our sunset review, they are more likely to grant us that statutory cap increase if they see that we have maxed out both the OTs and the OTAs. Whereas if we still have that wiggle room to go up further on the OTAs, there is a chance that they might say, you know, why don't you try increasing this first before we make a statutory cap change?
That's the piece I'm not quite understanding. So are you saying that it's more likely they'll approve it if we have the fees for OTs and OTAs the same because that will max out both. Is that what you're saying?
Yes.
Oh, okay.
Which is, I understand, historically has not been the case, and there are good reasons and arguments for why the OTA renewal fee has been lower. But just to inform the board that that's something to consider when making the decision.
Okay. Can I just ask a question about fees in general? Are we, and I know we talked about this at one point, but I don't know if it has gone through yet. Are we charging people, this isn't going to solve all our budget problems, but are we charging people for, what do we call that? When people are on probation monitoring? Because we talked about putting that into the budget, having probation monitoring fees. Is that happening now or no? That was going to be
I don't
coming
think
up.
that's currently in place, no.
Okay. Is that on the radar? We talked about it at one point. We were kind of, I thought, planning to implement that.
I would have to check. I know that we have a package in process that deals with the disciplinary guidelines, and
Gotcha.
I think that might be one of the updates in there, but I can't say for certain right now.
Yeah, I mean, as long as we're talking about the budget, I mean, there's other ways to generate revenue, but again, that's a very small population. I get it. This is a much bigger issue. Okay, going back, let's focus on this. Thank you.
If I could just add a little, so in statute, the limit for both is $300, despite what typically has been the difference in how you charge them. So it would just be a statutory. Because that limit, the legislature is looking for things to be at the statutory limits before they can bump them up. That's pretty much their reasoning.
Oh, I understand.
Okay.
And it's I have a question. So the we have never seen an analysis like the first one where it says how much it costs for each license. That it costs $312. The chart that says it costs $312. For a license. So that's true of whether, no matter what type of license it is that true of OTA licenses and OT licenses? There's no difference in the cost to the board?
The board's analysis was that processing both licenses costs the same.
Okay.
I would add that the renewal process, in terms of what needs to be processed by staff and what a licensee needs to submit to the board in terms of renewing, is pretty identical for the OTs and the OTAs. So I think the cost would be the same.
So even if it's a statutory increase in practice, are you saying that we wouldn't have to actually increase? Is that what you're saying?
That's correct.
Is that the message you're trying to give us?
If there was no need to actually increase the levels for the licensees, you would not have to. But if it came down to it, you'd have to implement regulations to bring the current fee levels up to the statutory limits. But just increasing the statutory cap does not change the fee levels.
And the legislature is looking at what we're doing in practice? Is that
correct? They're looking at.
I gotcha. Okay, I gotcha. Yeah. Okay.
So, Austin, don't we have we've been working on this for a while, and I thought we had something in the pipeline to increase fees, and we've voted on, we voted to increase them, and then we didn't have to increase them as fast, and then we voted to increase them again, and I'm confused about what we have in the pipeline. For example, what Christine was saying about the probation monitoring costs that we voted on, but then obviously there's an 18-month whatever time frame or more if it's getting statute. Are those in the statutory pack? Do we have a statutory package that's in process, or?
So there is no statutory package in process right now that would require, getting an author and sponsoring a bill. What Matt and Sam and I have been working towards, so just to give a little background, as you're already aware, this discussion of a fee increase has been going on for some time. And there had been plans over the last year developed to conduct a fee analysis through a third party. And due to the board's budgetary constraints this year, a $35,000 fee study didn't seem feasible or appropriate. So I partnered with Matt and Sam to try and get this done through DCA, and they were kind enough to help. What that means, though, is that we're further behind on our timeline than we were previously. So while the ultimate goal is still a statutory change that would, one, not just increase these renewal fee amounts, but there are other fees that the board charges, such as duplicate license fees and things like that, which are also capped by statute. So while that is the ultimate goal, increasing fees through regulation for the renewal, which is the only one that we have the room to increase through regulation, is sort of a stopgap or holdover measure to keep the fund condition solvent until we can get to a statutory change.
Okay, and so thank you. That's very helpful. And so the regulatory change, any regulatory change that we vote on typically would take 18 months to take effect. I mean, usually that's, more or less, maybe even could be longer. And then sunset is this fall, and next spring is when the sunset legislation goes in. So we wouldn't be there yet with the actual revenues at the time of sunset legislation. But if they're yeah, so I'm just trying to figure out the time frame for all this. But the legislature would see that we have a regulation in the pipeline, I guess.
Yeah, the idea would be that they would see that we've at least done everything we can on our end at this point in time to address the issue. And there's really, once we're at our statutory cap for the fees, there's no further action we can really take to increase revenue. So at that point, the only other option would be a statutory change.
Well, I've got no problem personally with increasing fees simply because $300 every 2 years, what's that, $150 a year to practice your profession seems pretty low to me. But it's going to be, I think, we're going to get a little bit of blowback if the assistant fees are the same as the OT fees, as the therapist fees. And it is an increase. So every time we have an increase, whether it's, a nominal amount or more, we do get blowback. Do you know offhand, Austin, I don't know if you've looked what the PT fees are. I don't know, and what their assistant fees are, their licensing fees.
I don't, but I can certainly look that up right now.
Yeah, I'd be curious to know. I mean,
Sure.
I just want to know how we're going to talk about this. I don't think the fees, even at $300 or even a little more, is really a lot, but I'm just curious. That's how I feel personally. But any increases is difficult for everyone.
Of course.
Well, also, when I joined the board shortly after that, I clearly remember several conversations on how so many other boards kept having their fees increased, constantly, while our revenue was so high that we actually cut the fees in half. So technically, we have some of the lowest fees still. So I think the increase obviously is very reasonable. We had a committee that was working on that, and they proved that, in fact, that it's legit for our board. The one thing I'm kind of not clear about, it was a little bit after the 2016-ish when we could have raised the fees after we went through the process. I mean, at least like the fact that we need to increase it, but then we were told the revenue is too high, so we couldn't do it. So how come that was already set up at some point, but now the cap is, this is like the only thing that is not clear to me. So now it's like, there's all these changes and we have these caps. Mm-hmm. And I know you weren't part of that, so I don't.
Well, and Matt and Sam might have some information to add about this, but my understanding is that back in 2016, there were a couple things that were different. One being that we had more vacancies, so there was more salary savings, and our fund condition was not declining as quickly as it is right now. And two, I believe, and Matt can correct me if I'm wrong, but there has been a slight philosophical change in terms of what might be an appropriate number of months in reserve for a fund condition. And I think the view might be that more months might be more appropriate for a little bit more financial flexibility. And to answer your question from earlier, Christine, the renewal fees for physical therapists and physical therapy assistants are both $300 for a biennial renewal.
Okay, well, that's helpful.
Hi, this is Matt Nishamini. Let me just make a few comments here. So yes, Austin is right. It's currently $300, but they are currently going through sunset review process. And there is a bill out there to increase their maximums to $500. And so as my colleague Sam noted, if you were to increase both the OTA and the OTs to 300 to the statutory cap, that would be looked on more favorably by the legislature when you go through your sunset process. It's just the standard process to make sure that the board is doing everything it can in its power to generate as much revenue within your current statutory levels before they amend the statute. Now, as Sam noted, it doesn't entail having a statutory increase doesn't mean you're immediately going to increase the fees again, right? You're doing this fee package now, and maybe in 3 or 4 years you opt to increase fees. All the statutory increase in the statutory caps, it gives you additional flexibility as you board members in the event there are unanticipated costs. For example, if there's some legislation that may increase workload to the board and you need to seek a BCP to increase your resources, your staffing levels, you would have that ability to increase your fees. Or for example, if your enforcement related costs, your attorney general or your division of investigation costs, if those costs increase in the future as you ramp up enforcement activities or what have you, then you have that flexibility. Since you're going through sunset next year, and if you don't take action next year to increase your caps, you're going to have to wait another 5 years before you could really have an opportunity to increase your caps. So there's going to be a period there where you would want to have as great as flexibility as decision makers of this board in the event those unanticipated costs materialize.
Thank you. Let's bookmark this part of the meeting and commit those comments to memory, because I think everything that you just said are great talking points. I don't see how we can get around this. I think this is something that we need to do. I think we're very fiscally responsible. I just think the cost of everything is going up. I just think this is just something we have to do.
I agree, Christine.
I just wanted to make one more comment about the regulatory process and the timing, so it's clear to you board members. So let's just assume you take action to approve a regulatory change, whatever you decide. We're not telling you what, that's your purview on what fee levels you want. But assume you want to change your regulations to adjust the fees. We would target July 1 of 2026, 12 months. These packages are relatively linear. There's not a lot of policy. We do a lot of these all the time. We probably do 4, 5, 6 fee regulatory packages for the programs every year. So we have a methodology, we have a system in place, and we would work with with Austin, your executive officer, to really target July 1 of 2026 to get this done.
Beata, do you want to have comments from the public? Or?
Yes, I will. Just for clarification, I know that initially a couple of years ago when we voted to increase the fees, did any increases happen in the past couple of years at all? Or that never happened?
I'm not aware of any package currently in process to increase renewal fees. And
because that's what we remember when we voted for, and it was very specific, like at a certain year. I should look it up. I will look it up for the future.
Yeah, and then it was held up in part because the board voted to take some action, but then the fee study was a requirement. I think I was president during that period of the board, and that the fee study was a requirement in order to proceed with all the complex of fees that the fee schedule that the board committee recommended and that the board approved. So the fee schedule was with the one Austin was talking about, then it was performed through internally instead of sending it out to a contractor, and that's what we're getting the results from now. So I think I don't know what we don't have that package in front of us before us with what we were looking at that Denise Miller and Lena Doe worked out and that the board voted on. Obviously, we don't have that here to look at and to refer back to, but I guess we could start with just maximizing. Hearing this information is new information that we're having. The cost of a license, that's new information that we didn't have before, which is part of this analysis, the cost of each license, and also the information that about the current tone in the legislature, the way the legislature is working these days is to work to maximize the current statutory cap before moving on. So we would still need to figure out what we would want in the legislation, but today I feel like we could probably consider voting to just maximize this within the statutory cap, and then come back to that at maybe one of our next meetings, try to pull the history out and go over it for any statutory change that we want to make.
And I can certainly find the discussion and sort of the language that was discussed at the prior meetings about all the fee increases. If I remember correctly, I'm remembering that happened now, and there were other fees involved other than just the renewal fees. So that's something that I can definitely reference as I work with Matt and Sam going forward to develop the justification for the statutory increase. We can definitely reference that as we're laying down the justification to the Sunset Committee for those changes as well. But today, the only flexibility that we have at this point in time is with our OT and OTA renewal fees, fortunately.
It seems like this is the equivalent to our fee study that we've been waiting for to proceed with any legislative package, and that the recommendation, the natural outgrowth of these recommendations is that we would maximize with fees within the current statutory caps. So,
and my understanding could be wrong here, but my understanding is that even had the third-party fee study taken place, the expectation from the legislature would still be to have seen statutory caps reached before approving a change to the statute.
Do we have any comments from the public?
The Ada Boone Hurl here. This has been an extremely educational conversation, and one that as an educator and a practitioner, I very much appreciate. And while listening, I've been sitting here trying to figure out how I would explain to students and colleagues the rationale behind decision. And that leads me to just for the board's consideration, as that process happens and you've completed this difficult navigation of a potential change, then some simplified dialogue to help those understand, and perhaps providing some of that as a talking point to educational programs as well, so that then we could then clarify, because we would, as educators, be clear on what's going on. my thoughts are disjuncted because this is brand new to me. But one of the things that I very much appreciated as a listener of the public is the workload justification, that it's not so that's one thing I think that's important to emphasize, that I would emphasize, for example, to my student, that the workload justification shows that it costs more to give you this license than you paid them to do it. And I also appreciate the PT information because I didn't realize that they didn't have a distinction between level of practitioner, PT, and PTA. So because the cost of processing a license is cost of processing a license versus recognizing the practitioner level license. So I thought that was interesting and could be an important part for supporting that justification. And definitely, not saying, well, we're doing it because PT does it. That's not what we're doing. But I would also be mindful of saying that when I'm explaining to others that that was part of the discussion. The other part that I was listening and I really don't know anything about, but I found interesting was, for example, probation monitoring. Even if it were a nominal fee, and I don't really know anything about this, I'm just as a naive listener expressing that if we're doing the work of monitoring somebody who has done a legal infraction, then I would think that we would work to retrieve at least a little of that cost, if not the full cost, in this workload analysis of doing that. So, because then that could be, perhaps another incentive to clearly learn the requirements of being a practitioner at any level and follow the required law in practice. It's going to cost you this, and this, and just as another component. So I think well, I think that's it. I'm working through my notes here, and I think those are my thoughts, and I really appreciate the opportunity to express them. Thank you. Yes.
Thank you.
Samia Rafidi here. Thank you, Ada. I agree with you about, what needs to be done needs to be done. Money is difficult for a lot of people. Cost of living is very difficult. Doesn't look like things are going to get better. So I did a quick search online and saw that in the state of California, an occupational therapist could make between $80,000 and $120,000 with their license, with their work. And so a fee of $300 would be about 0.25% of their salary, up to 0.38 of their salary, depending on how much they're making. An OTA makes roughly $75,000. So the new fee of $240 would be about 0.32% of their salary. So it kind of seems like balanced to me between the OTR and the OTA. If the OTA moves up to 300, which is an option, then that would become 0.4% of their salary, which is a little bit higher than an OTR. Given the discussion about physical therapy assistants, I love what Ada said, like, we don't want to keep comparing ourselves, but it's a very similar profession. And it's obvious that the money is needed. Where my head goes as president of our state association is that if people are paying more for their license, they may choose not to pay for their membership for the state association. Not that that's anything that this board needs to concern itself with, but as colleagues, I think you would understand that that's a concern that I would have in the seat that I'm sitting in. So it's already hard enough to get members to join the state association. And so picking and choosing where their funds go, this could be really hard for the state association. Thank you for listening.
Can I respond to that?
Go ahead.
Yeah. Having been a past president of OTAC, and Richard too, I think we can sympathize with that. at the same time, that's always been an issue. And yes, Sammy, yes, of course. Yes, of course. We understand that. But like you said, we have to do what we have to do. I went out to eat last night. There were two of us. We spent $100 and it wasn't like a fancy restaurant or anything like that. So, I don't know. People choose where they want to spend their money. And I guess that's my response to that. I think, yeah, that's all I'm going to say about that. But yes, I understand, Sammy, as president of that association, of course, we all understand that that would be one of your concerns. Yes.
Agreed.
I agree with Christine, and as she said, I do sympathize with that. And one of the reasons the board has always had a differential between the OTA and OT licensing fees is in recognition of the difference in incomes and pay between the two OT practitioner types. And then retiree fee and whatnot is even lower. Unfortunately, we are obligated by statute to maintain our a fund condition and be self-supporting in that way. I was going to say something else. No, it's escaped me, but we would certainly look at the probation. What Ada was saying about the probation monitoring costs. That was something that this board has discussed in the past. If my recollection is correct, we would need statutory authority to add that because we don't have the authority to charge a probation monitoring cost. So we would have to go to a statute to do that. Yeah, so that if this is the way to get there, then we might have no choice. Oh, I know what I was going to say. I am also sensitive to the fact that we have 4 board members now. We're down a couple of practitioner on our board, and our OTA position is vacant, so we don't have an OTA currently represented on the board. So, so I'm a little bit, if only 2 OTRs voting to end the differential between the 2 fees. I'm sensitive to that, how that might be seen and taken, but we do have facts before us that indicate that would support making that decision.
So speaking just as an OTA practitioner, I appreciate that comment very much, that it recognizes our differential. And I also appreciate Ms. Rafidi's comments in her exploration of the percentage of impact that a fee would be. I can't speak for all OTAs. I would, if I were to no longer as just a generic OTA, have the differential now change to where it's both the same, what would just like in practice, the evidence helps me to see the why. And so I would like to really see that, an explanation that how a statutory cap works, that the legislature doesn't see the difference in what we do. It's that it's a fiscal process. And what the workload analysis looks like, that the OT costs just as much, the OTA costs just as much as the OT licensing process, but also a more formal analysis of the average wage. We can look at it nationally in California, very easy to find, and look at if it increases this much, then this is this percentage of your wage. And so you might find that, and we're being transparent, even though we're going to make you both even, we're transparently letting you know that we recognize this might be a little bit more out of your pocket. Kind of thing, because so the evidence behind the decision and the transparency would help me as an OTA personally feel less impacted, that it's like, okay, I get it. as opposed to just like, well, you know, well, I don't make as much as you, OT, and walking away with harder feelings or misunderstandings, because then that would help the public conversation amongst people and practitioners that this is why they did it, and not feeling slighted or secluded. So I just want to throw that out. Thank you very much.
Thank you, Ada. I did want to, just in response to that, as part of the regulatory process for getting a package approved, there are portions of that process that involve making the proposed changes available to the public for a 45-day comment period. And even before then, part of our process would definitely include developing messaging for both OTs and OTAs to explain exactly what your concerns just were, what the process for the fee increase looks like, what is the justification and the rationale behind it. And we can also include information about, you know, what to expect moving forward, you know, letting people know, hey, this isn't just, you know, gonna keep happening every year. This is why we're doing it. So there would be messaging involved that would get those points across.
Thank you for that clarification. I had forgotten about the 45-day public comment piece of it. One other thought that I had forgotten is, all of that said, knowing that my license might go up higher and that sort of thing, if you have to increase the statutory cap, and we know that the process is so lengthy and the world is so unpredictable, we want our licensing board to be viable, because we want our licenses, and we want a staff and a board that can function. And so if it requires increasing a cap, which we know would take along, where it's both even and increasing it legislatively, and there's a regulatory mechanism somewhere along the way, if I'm understanding the information, then it seems like we do have to be future forward thinking in very unpredictable. We don't have a pattern of life in the years coming forward from where we are today.
Ada, for that comment. We really appreciate that. Thank you, support. Can we please open it up to the public on the web?
Thank you, Madam President. If any member of the public logged into WebEx would like to comment on this agenda item, please raise your hand. We will give you a moment. All right, this is a moderator. I see no requests for comment. Madam President, I return the floor back to you.
Thank you so much, Tricia. So, either Austin or Sam or Matt, whoever, could we just have one recap again, the two options, the exact options that we have before us, so the board can look at it and discuss that, and so we can go from there?
Can I add one thing before we go over those?
Of course.
I did want to add, and I think Matt hadn't or Sam had mentioned this earlier, but right now in statute, the cap for the renewal fees for OTs and OTAs is tied together to the same subsection. They're the same amount. So this opportunity to ask the legislature for a fee increase through the sunset process could also be an opportunity to separate those two caps so that we would not have a similar situation to this in the future should another statutory increase be needed. So this could be a good opportunity, although it involves increasing them both to the caps now. We can ask for those caps to be separated, and that way we wouldn't have to increase them both to the same amount should another statutory change be needed in the future.
Okay. Should I talk about the options?
Yes, please. Thank you.
Okay. So if the board chooses to increase fees, the two options we have laid out are to increase the biennial renewal fee for OTs to $300 and the biennial renewal fee for OTAs to $240 as one option. Or the other option would be to increase both fees to the caps of $300.
Can we vote to increase, let's say, both of them to 300, meanwhile asking for to separate them in the future?
So asking for the separation would not be a part of the regulatory proposal. It'd be a part of what we ask of the legislature when we tell them that we need to increase the statutory cap. Yeah.
Can I offer a motion? Or is it too early for that?
For you to offer an
Yeah.
option and a
motion.
motion. Sorry, I'm like,
I'm sorry.
Yeah.
May I offer a motion or would you prefer to discuss this more?
Just for a second, please. What is your idea? Just to make sure that everybody's we have a little bit
Yeah.
of understanding.
I mean, I think it's pretty clear we need to ask to increase the statutory cap to 300 for both. To me,
Okay.
Okay. That's how I see it.
Okay. Richard?
I speak in favor of that, making them the same, increasing them both to the maximum statutory that the statute allows.
Again, that doesn't have to do it in practice. It's just gives us wiggle room.
Well,
if we need, like Matt said, I'm sorry, I can't see Matt's full last name, so I can't say Mr. Nishi something. I can't see the full name, but
Nishamini.
Okay.
Well, if we do a regulation to increase the fees to 300 for each, both OTs and OTAs, that would increase the fees to 300 for both OTs and OTAs next, from what Matt said, next July would be the target. But then the statutory cap increase would be something that we would have to look at separately.
Oh, gotcha. Okay, yeah. Okay, well, we just, yeah. Okay. We have to do it.
Okay. Hector, do you have any comments?
I just want to know why the increase in the fees. Maybe I missed something here. What's the purpose in this $300 fee?
The reason for the fee increase is because the board's fund condition has been and is projected to be in a decline, and we need the board's fund to remain solvent to continue to operate, and increasing renewal fees, the fees that we charge to licensees, is really the main avenue that the board has for generating revenue. So it's the option that we have to keep the fund solvent.
Is there a projection that it might go up higher the coming year?
The fund or the fees?
The fees.
So there is I don't know if there's a projection that it'll go up higher, but there are other fees that the board charges that are limited by statute, like the duplicate license fees and license verification fees. So that would be also included in a statutory change. So while the statutory change might increase the cap for renewal fees and give us that flexibility, it also gives us the flexibility to distribute that out to the other types of fees that the board charges. So just because we increase the statutory cap doesn't necessarily mean that we are obligated or that we would choose to follow that cap in regulation, if that makes sense.
Yeah. Thank you.
Thank you, Austin. All right, I think that we're ready for a motion. If you are still interested in placing one, making one.
Have a quick comment.
Oh,
We have a comment from Regs Council.
please.
So I just wanted to remind everyone that we do have the proposed regulatory language, the proposed text before you for a potential motion. There is one small error at subsection F. It's the last page under this agenda item. Subsection F, it is talking about the biennial renewal fee for the OTAs being increased to $300. And then in the parenthetical, it still says 210. That should be struck out. It should be replaced with 300. And so if the board is looking to increase both to 300, then I propose that we do a motion on the actual proposed text, and then we can move forward with the rulemaking process.
Could you just repeat that? Because it took me the duration of your comment to find the page
get
I was
to the
looking
page.
at. And so if you could,
Sure.
it'd be really great if you could just repeat it.
Yes, of course. So the proposed regulatory language on fees for section 4130, if you go down to subsection F.
F, okay.
Yep, which is referring to the biennial renewal fee for an occupational therapy assistant. At the end of that subsection, the language of $300 is followed by a parenthetical that says 210. That should in fact be $300, the very end of subsection F.
Okay.
So the proposed text is really a change at subsection E to bring the biennial renewal fee for OTs up to 300, the statutory cap, and then subsection F to bring the renewal fees for OTAs also up to the statutory cap of 300.
Thank you.
Thank you.
Hey, Richard, since I can't even find that language in my packet, can you make the motion?
Yes.
Thank you.
I move that the board adopt the proposed regulatory language as
Adopt or accept? Approve.
okay. I'll strike that. I'll change the motion. I move to approve that I move for the board to approve the proposed regulatory language as presented before us for section 4130 fees.
With the exception of
With-
F.
With the modification to F to as changing that from 210 to 300 in the parenthesis.
Okay, if that motion.
And allow the staff to make non-substantive changes, or yeah.
Okay,
Sorry.
if that's a good motion, I'll
Yeah.
second it. Okay.
Great. Do we have any further board comments, discussion? No? Okay. Can we please open it up to the public? Oh, here first. No, we don't have any comments here. Trisha, could you please open it up on WebEx?
Thank you, Madam President. If any member of the public logged into WebEx would like to comment, please raise your hand. We will give you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you so much. So let's take a vote, please.
Hector Cabrera,
Yes.
Richard Bookwalter, yes. Christine Wittlisbach,
Yes.
Beata Marcos.
Yes, and motion carries. All right.
Can I make a quick comment, Madam Chair, President?
Sure.
This comment is directed to OTAC representatives, and today it's Samia, the president, and also Ada Boone Hurl. I just want to say that you guys are always at our meetings and often at our committee meetings, our board meetings, often at our committee meetings. You always have thoughtful, articulate, balanced input that's so helpful and relevant to the discussion. And I just want to say that I, for one, and I'm sure everyone on the board appreciates that. And I just want to say thank you so much for always showing up and helping with the discussion in such a helpful way. You know, we appreciate that very, very much.
1,000,000%. Yeah, come on, go ahead.
I just really want to say thank you very much. I think both on behalf of me and Samia Rafidi, those comments are very kind and generous, and we appreciate being here and being a voice for those who can't be here. And thank you for the recognition and the opportunity.
Thank you so much. I love all the love in the air. That's awesome. All righty. So I would like to, at this moment, to thank all of our presenters and for all your hard work and support and helping us in Austin to get through this. We really appreciate it, and we look forward to working with you in the future to make this happen. At this point, we're gonna take a short break, maybe a 15-minute or until 11. Okay, we'll do a 20-minute break and we'll come back at 11 a.m. Thank you so much. Okay, welcome back, everybody. Can we please reestablish the quorum?
Hector Cabrera, are you here?
Yes, present.
Thank you. Christine Whitlisbach,
Yes, here.
Richard Bookwalter, I'm here. Beata Marcos?
Here. And we have a quorum. Thank you. The next item on the agenda is 21, consideration and possible action to initiate a rulemaking package to amend California Code of Regulations, Title 16, Division 39, Article 7, Section 4161, continuing competency. So I will hand it over to Austin so he can give us a little outline of what this is exactly.
Thank you, President Marcos. So the agenda item here deals with the board's previous discussion at the last meeting in March about whether or not to implement a jurisprudence exam or jurisprudence continuing education requirement. And the discussion at the last meeting seemed to indicate that the board's preference would be a continuing education requirement. And so staff took that preference and worked on implementing some language to make that a reality. What we have before us today is language that includes that change as well as some other changes. These other changes in the language have been approved previously, I think years ago, and there's a package in process right now which includes these changes. However, if we're going to make additional changes to that code section, then we need to kind of have it needs to all be together in one package. So the language here includes those previously approved changes as well as additional changes to implement a jurisprudence education, continuing education requirement. There is also one additional change on, let's see, subsection D9 on the second page. It's the second number from the bottom that deals with receiving professional development units for attendance at a California Board of Occupational Therapy meeting. There's some clarifying language in here to make it clear that attendance at certain meetings might not qualify for those PDUs. For example, over the last year, the board has had a few meetings that consisted of a very short 15 to 20-minute open session, followed by a closed session discussion for executive officer selection or what have you. And this is clarifying that those meetings, there will be from going forward, there'll be a disclaimer on the agenda for those meetings that they would not qualify for professional development units. And then as far as the continuing education jurisprudence requirement goes, right now that is slated for subsection B on the first page. And it seemed like at the last meeting, there was still some room for discussion in terms of how that would be implemented. So on the final page, you can see a couple of options for what that subsection B would look like. Option 1, in effect, would require a minimum of 2 PDUs to ethics and healthcare, 1 PDU about laws and regs or jurisprudence, and then a third requirement for working with diverse populations. The second option would still require the ethics requirement. However, it would give licensees applying for renewal the option of either doing a jurisprudence course or a working with diverse populations course. There are some mostly non-substantive changes to the language that had been approved previously that got some second level review from regulatory counsel to increase the likelihood of this getting approved by OAL. So we can talk about what those updates are. Let's see. Well, maybe we can leave it up to the board. We can kind of go in pieces here. If we want to talk about the jurisprudence requirement first and how maybe that should be implemented, and then we can talk about the other issues with the language. Oh, this is just for me.
Jimmy, can I start with my thoughts on this?
Yes.
Thanks. So I appreciate the language, because one of the things that was bugging me about looking at this earlier is that we used the word course versus PDU in previous versions of this, and I thought that was confusing. This the proposed options for 4161B here stick to PDUs, and I think that's a lot easier for everybody. It's going to be easier for the staff. It's going to monitor and assess, and it's going to be easier for the practitioners who are getting the PDUs. It's clearer. I do think we talked about a course which sounded longer than 1 PDU for some of these things, but I'm okay with, I tend to go on the side of minimally encumbering a person's in terms of making them do this PDU, making it too granular with the PDUs, and you've got to do this PDU, because I have continued to have the concerns about people not fulfilling, maybe getting 30 PDUs, but they didn't have this one, so then they're in violation, and that's always been a concern of mine. So I'm okay, and I think 1 would be clearer than 2. I actually was looking at an option. I was thinking at a previous discussion about a third option, which is combining the ethics and the jurisprudence, not giving them an option to do ethics and jurisprudence rather than an option between DEI and jurisprudence. However, I think 1 is the clearest. Option 1 is the clearest because it's just set out. Giving people options can be sometimes challenging. So say you need one of these, and one of these. So I'd like to speak in favor of option 1.
I will also speak in favor of option 1 because, as you know, I've always been in favor of people needing to take a course in California Business and Professions Code. And I don't like the idea of people having a choice to opt out of that. So option 1 just says you have to study the law. You have to know the law. So I speak in favor of option 1.
Motion?
We could probably do a motion at the end once we've gone over the whole language, but it would be good to have sort of a consensus, which it seems like we've reached, unless we might want to go to public comment or see if Hector has an opinion about it. But I do want to add, for option 1 here, there was a discussion with Regs Council pertaining to the third requirement, and this actually would apply to both options. I wasn't around for when this culturally relevant practice language was developed, and we were curious if there was a specific reason why the terms culturally relevant practice and sociocultural factors were included, Specifically, was there intent to cover something with those two terms that wasn't covered by working with diverse populations and or bias? Is it something that the board still feels is necessary to have those terms in there, or would working with diverse populations and or bias sort of cover the intent?
May I just speak to that? I mean, I think working with diverse populations and or bias would be fine. Sociocultural factors are that's a term that's used, I believe, in the OT practice framework. You may find that in the OT practice framework document. I would have to look for it, but that's a common term used. And culturally relevant practice is also a common term. Those are common terms. I mean, OT study, that's part of OT, regular OT practice, but I don't think they need to be there. I don't see the harm in them being there.
I think it's a good thing that diverse is kept in there, because it seems that, doesn't seem, but it's shows that everyone's included in this. Does that make sense?
I was wondering if maybe to answer your question, Austin, and to piggyback on what Richard said, the terms culturally relevant practice and socio-cultural factors, just because those are very OT terms, I'm wondering if that would help identify courses. Like, I'm wondering if people use those terms in the title of their courses, it would help practitioners identify courses that would meet this criteria, if it would be helpful. I'm wondering if it would be helpful just to leave it in, along with what Hector said, diverse populations and bias.
Yeah, absolutely. That was one of the main reasons why I asked. I wasn't aware that those terms were maybe more commonly understood by practitioners in the profession. So if the board feels that it would be evident to a licensee reading the regulation, they would know what that's referring to and it would help them identify courses, then certainly I think it would be appropriate to leave.
I'd be interested to hear what OTAC thinks, and also Ada Boone Hurl, if they might have a pulse on this.
Okay, we're going to open it up to public comment, please.
On this particular subject, two things. One thing I remember in previous meetings that I think that the intent of this was not to be a class, but to have the other classes be inclusive of and address bias. And I'm only speaking from memory. I do not have a document with a meeting date in front, but I was surprised when I saw this because I thought it was a feature of the other potential requirements that are before the board today. In terms of culturally relevant practice, sociocultural factors, diverse populations, and bias, those are factors that are included in ACOTE standards. And I understand that this is continuing competency that would refresh members over time. But we have it captured as part of ACOTE standard. If there is a way to, yes, it's incredibly important, especially in the state of California. The other thought, though, is now we're up to 5 of our 24 units of continuing education is about these topics, which are important, I agree, as opposed to currency and practice and interaction with patients. So I'm wondering, is there a way to find a balance where maybe not such a high proportion, where the DEI is a component, like it could be an an ethics and cultural responsiveness, et cetera, type of course, one that could be created that addresses the multiple factors in that. Because there's ethics courses galore, but you would not necessarily be able to find one that fits this requirement. It could be custom made. It could be what California wants in that process. Thank you.
Thank you.
Can I respond to that, please?
Of course.
Okay. I think those are really good comments. Two things. I don't think the intent from my memory was ever to have the DEI stuff rolled into the other courses. I don't remember that being part of our discussions, unless I misunderstood the discussions entirely, but I don't think that was ever our intent. And two, I do understand that, we are up to around 5 units now out of our 24 per renewal cycle. And that is always an issue when you start prescribing, like, what people need to take. However, I would really hate for us to say, like, oh yes, let's say that there has to be this one course created that includes ethics and DEI information, because people already are subscribed to continuing education packages like MedBridge and things like that. And if MedBridge doesn't have a course like that, even though they already have lots of ethics courses, they're not going to be able to get that one course that would meet this criteria, whereas they might, for sure would have, and I know so many people use MedBridge, and it's free from a lot of employers. Like my employer offers it for free. You can get your ethics course, you can also get a DEI course, you can also get a lot of other courses, so it's easy to satisfy that, as opposed to like waiting for someone to create this one course and then that's your only venue to get that course. I just would not want to see that. People can take more than 24 units of continuing ed if they want more information on a particular topic. This is just for license renewal, and I do understand that it's 5 required things that they have to get their license renewal in California, but it's things that the board has deemed important. So I don't have a problem with keeping it as is in option 1 and making sure that these courses are easily accessible. Now, having said that, courses will need to be created specifically on California licensing, and those courses will need to be created. And we've talked to OTAC about them creating these, and other venues can create them as well.
Well, the great thing is OTEC is in the house, so please.
Okay, so this is Sammy Rafidi and, oh, is that working? Here.
It's not on. It's just there's a gray button. Just press on it.
Oh,
Thank you. Yuritsa Rodriguez. And I just want to reference the OTPF very quickly. And cultural identification and attitudes, social background, social status, and socioeconomic status are under personal factors on page 10 and 11.
can you give us the definition for, was it culturally relevant and sociocultural factors that was in there that you pointed out? Lost it? Okay, while you're looking, I have a clarification question. I guess the original question was, is culturally relevant practice sociocultural factors in working with diverse populations and or bias, is that all necessary? Or is it redundant?
I believe, yeah, that was the intent. The way it was originally phrased was there anything covered by culturally relevant factors? Sorry, I lost the text here. by culturally relevant practice and sociocultural factors that was not covered by diverse populations and or bias. But I think Christine did mention that that might be terms that are used in the courses, so it might be easier to identify for practitioners.
Got it. So the desire would be to keep it as is.
Well, that would be up to the board, but
That's the conversation. Okay. I have one more question to ask if you're still looking for these definitions. Okay. When I read option 1 and I see the number 1, 2, 3 underneath, it looks like there's 3 options there to choose from. And maybe this is just the way I'm interpreting this, but number 1 is that you need a minimum of 2 units related to ethics in healthcare. Is the jurisprudence considered ethics, or is that number 2?
the intention was that jurisprudence would be separate from ethics. I believe on option 2, subsection B1, where it says a minimum of 2 PDUs related to ethics in healthcare, comma, or that should be comma and. That's an error on the part of the text there. So the intent behind option 2, and again, the board can prescribe however they'd like. This is just a sort of a jumping off point. But the intent behind option 2 would be that a licensee would be required to do 2 PDUs in ethics, and then in addition to that, have the option of completing 1 PDU in jurisprudence or 1 PDU in culturally relevant practice, sociocultural factors, working with diverse populations and or bias.
So then that means that some people might not choose the jurisprudence.
Absolutely. Yeah.
But isn't that the whole idea, that we want everybody to have the jurisprudence?
Right. So it's an option because the discussion that the board had last time seemed to indicate that there might be some reticence to prescribe so many different requirements. So it was presented as an option to the board, but it seems like they might be in favor of option 1 now.
Yeah, I was expecting to see this differently. I was expecting to see ethics or jurisprudence and diversity, and the culturally relevant practice one. But that's so that's my understanding of what I was. But anyway. One is missing an and, right? The option 1 is missing the and after 1 after B1. Should there be an and at the end of that line or not?
For option 1, it's 3 separate requirements. So it's like a list: 1 followed by 2 and 3.
It's so it's like the Oxford. Okay.
Yeah.
Okay.
So someone could either do 1 unit in ethics or 1 unit in the DEI OJ.
Under option 2.
That seems like option 1 to me. Option 1 is confusing because
Option 1 is they need 2 PDUs for ethics, 1 PDU for jurisprudence, and 1 PDU for culturally relevant practice. Those are all 3 equal requirements. 1, 2, and 3 in option 1.
so that seems like 4 requirements to me.
It's 4 PDUs.
So you could have 2 for ethics, 1 for jurisprudence, and 1 for DEI OJ.
You must have those.
You must.
In order to get your license renewed.
That's option 1, Samia.
That's option 1.
Oh, I understand now. So 1, 2, and 3 are musts, not you have to choose 2 of
Correct.
these.
Correct.
Correct.
Got it. Okay, that's clear. So then you're going to require 4 out of the 24 to be these 4.
Right, because OTAC came to us when Bryant was president and said, can you add something about diversity, equity, and inclusion? OTAC wants you to called on us to do that because we feel that it's important, and so the board voted to do that. And then the state business and professions has asked, that we've been asked to do that from a previous sunset to consider adding an ethics or jurisprudence exams have also come up in past sunsets as things that are coming more from the state as what other boards are doing, and there's a support for that. So we added ethics uh, at their request, and then jurisprudence was the most recent one that came up again,
Got it. Okay, so that helps.
driven probably by the state, a little bit more by the mood of the state, what we should put, not the mood, but.
Got it. Okay, so I guess maybe I was getting confused with the way it was written, but that helps clarify.
Samia, could you just hold off for a second until?
Thank you for that, because I think a simple change to the language could help clarify. Oh, can you hear me now?
Yeah.
Yes, you can. Thank you for your comments, because I see what you mean. So under option 1B, I suggest moving the language of a minimum of that's currently at the front of subsection 1. I suggest we move those words to the top. So it would say, for a license renewed on or after January 1st, 2027, of the PDUs required for each renewal period, licensees shall complete a minimum of, then you have the semicolon, and then you have subsection 1, which would start with 2 PDUs related to ethics, comma, 1 PDU pertaining to laws and regs, and then subsection 3, 1 PDU. Would that be more clear?
Absolutely.
Okay.
Yeah, I do
Perfect.
think that clarifies it.
Okay,
Okay.
great.
Yes,
That's
perfect.
beautiful.
Do you feel that an and is required after subsection 1, or would that have solved the problem?
Can you repeat that so I can follow where that is?
Sure. So I'm wondering, we're kind of using the Oxford comma and situation here by saying subsection 1, 2 PDUs related to ethics, comma, subsection 2, 1 PDU pertaining to laws and regs, comma, and subsection 3. So just to have it very clear that we want all 4 of these required, we could suggest, or we could amend this to have an and at the end of subsection 1, a minimum of 2 PDUs.
Yes.
I'm sorry, 2
Let's do
PDUs. Yeah. Okay. Okay.
Yes, let's do that.
So
Yes.
That helps.
2 PDUs related to ethics and healthcare, and so we'll have 2 ands in that option.
Yes.
Okay.
That's
great.
very, thank you for that.
Thank
Yes.
you.
And moving in the minimum of is great.
Okay. Perfect. Thank you.
Okay, and yes, Richard, when you mentioned OTAC, maybe it was Richard or maybe it was Christine that mentioned OTAC is very interested in owning the jurisprudence piece and developing that PD. We would love to do that. And we're putting our name on the table to do that. So whatever that means, we're in.
Right. And that doesn't mean that other people couldn't do it as well, but we're very happy that like you would do that, because there's nothing out there right now.
Yep, you got it.
So thank you.
So
Yeah.
this is going to this will be until 2027. There's time.
Right.
Yeah.
There'd be that, and that's kind of baked in is to, 1, there's the regulatory process, but 2, we wanted to bake in some time for a course to be developed.
Sure. Okay, sounds good.
May I ask whether you guys have an opinion of in the language in option 1, section 3, the whole culturally relevant practice thing? Do you feel like shorter would be better? Yeah.
I do, but I'm not quite sure what it would be. I want some time to think that through. And I thought maybe we could find the definitions in the OT practice framework, but we'll keep reading back there. And do you need that today? Is that necessary?
Yes.
We're going to vote on it today.
Yes,
yeah.
okay. Okay, we'll give us a minute or two. I do think it's wordy. It seems redundant.
It seems redundant, Samia, but I really do believe that it's going to help practitioners identify courses out there, because people are going to use these words in the names of their courses. And I think it's going to be helpful. But if you guys come up with something better, let us
Okay.
know. I don't
Okay.
think shorter is necessarily better. I think it's better for our language, but I don't think it's necessarily better for people trying to interpret our language.
Got it. Okay.
Another thing is, even if we voted to accept, let's say we voted to adopt this language today, is there not a 45-day comment period?
Yes, there would still be a comment period for members of the public
And
to make
comments.
comment.
Yeah, so if people were to have comments and that would come back to the board and could look, if we voted to change it, then there'd be, I think, a 15-day comment period.
Be 45, and
Another
then
45.
can address comments and make any changes, and then followed by a shorter 15-day comment period. So there's opportunity for the language to evolve even once it gets submitted to OAL.
Sounds good. Thank you.
Thank you. Yeah, go ahead, Dita.
So I very much appreciated this conversation because I've now gotten my brain organized in that I see the points of why what's here, which wasn't clear to me in just reading a document alone. So that's been very helpful. In the discussion regarding the multiple items about sociocultural, et cetera, it does have an and or, and I do think that having it spelled out like this would help reading a course description, not just a title, in order to identify, oh, this course qualifies. And as the original author 20 years ago of one of the first healthcare and multicultural society courses in the state of California, I definitely believe it needs to be there and as is. Thank you.
Thank you, Ada. Samia, do you need more time finding the information you wanted to present, or I'll go to public comment on WebEx. Hi, Trisha, could we please open it up to public comment on WebEx? Thank you.
Thank you. Sure. So if any member of the public logged in on WebEx would like to comment, please raise your hand. We will give you a moment. All right, I see no raised hands. So Madam President, I return the floor back to you.
Thank you. So
So we've had some comments about changing the language and keeping it the same.
Well,
So-
with minor changes.
No, I mean about the on option 3. I mean, I would be okay with just keeping it as is but making the changes that were suggested by DP. And then sticking with the rest of the language in option 1. And I don't know if we're ready for a motion to that effect.
It might be worthwhile discussing the other changes that had been approved previously, just because that language has been tweaked a little bit on the recommendation of Regs Council. So we could just take a look at what some of those are, just to make sure that the board members still agree with how those changes are being implemented here.
That sounds good.
So let's see here. The first change would be in subsection, in this version, it's now subsection D, or dealing with supervision, credits for supervision. Supervising the field work of level 1, level 2, or doctoral capstone occupational therapist and or occupational therapy assistant students shall be credited as follows. So the prior package had that inclusion of doctoral capstone students, whereas previously it had just been level 1 and level 2. Let's see, we have, so that change is the same as what it was before. If we go down further to A, B, C, D, what is the new D here?
9.
9?
That's what you mentioned earlier.
Subsection 9?
Mm-hmm.
Oh, still looking in that, so dealing with the doctoral capstone students. So there was section 4, and then if you go down 4A, 4B, 4C, 4D, there was just a minor change implemented here. Previously, the language had said supervising level 2 or level 1 or level 1. And we just thought it would be more consistent to switch the order, since it's listed 1, 2 doctoral capstones in the sections above. It might just be more normal to list 1, 2 doctoral capstone students in this section here. So that's just an order change on those. And then we have the change in section 9. And this is actually new. This hasn't been approved by the board previously. So this might actually warrant some more in-depth discussion before we go on. This is, again, as a reminder, the clarification that certain meetings of the board that consist mostly of closed session would not qualify for professional development unit credits. I don't know if we want to pause and discuss that or move on and come back to it.
I think we're all in agreement to that. There's no substance to those meetings.
Yeah, and it is, this has always been the case. This is just clarifying to make it more clear to a licensee reading the regulations. But if there's no further discussion, I can move on.
Yeah, I have no issue with this language in 9 changing the proposed language in line 9. So,
okay,
I support it.
Perfect. So moving on, we will go to subsection what is now E, referring to not receiving partial credit. And then we've added on at the end here that a maximum of 12 PDUs may be credited for the activities listed in subsection D per renewal period. Just a minor clarifying addition there. Following that, this is a previously approved change dealing with, so at present, a licensee who receives their initial license will have their first renewal period prorated, and we do not require professional development units on that first renewal because it is less than the 2-year renewal period. This change includes language that would make it so that if their first renewal occurred more than 1 year after the issuance of their initial license, they would have to complete half of the 24 PDUs normally required for a 2-year renewal period. Following that, we just have a quick change of the word must to shall. That's language that's generally preferred by the Office of Administrative Law, but again, non-substantive there. And I believe that summarizes all the changes in here. Oh, actually going back up to the top on subsection C, this is another previously approved change. There was a statute that the board had made this change in response to previously, but elimination of the term post-professional. So just pointing out to the board members that that change is still in here for the new package. There is also one item to consider. So right now, the PDU options that we just discussed regarding the additional requirements, this subsection B, there was debate, or it might be worth just considering for the board, whether or not that would be best placed as option B. And there is reason for putting it there because the following section talks about topics and subject matter shall be pertinent to the practice of occupational therapy. And it sort of describes what the courses should cover. What is the requirement for something to sort of qualify for a topic? But if you go down further to what is now subsection G on page 3 of the document, subsection G talks about the number of the PDUs that must be directly related to the delivery of occupational therapy services versus those that might be indirectly related. And it's just worth discussing whether or not this new section that places further requirements on what the PDUs should cover would best fit down here with G, where we're talking more about what the PDUs must cover, or if it's more important that it's up towards the top where it's not easily missed. So that just might be something the board wishes to discuss.
I have a question for you, Austin, about what is the staff, because the staff auditing these PDUs during the routine audits sees the violations and has interaction with the licensees about that. I do think it goes with G, but sorry. Yeah, the staff might have some input on that because they are the ones interacting with people who say, I didn't see that in the regs or whatever, or have questions about what G. I know that questions about G come up.
Questions about G definitely do come up during audits, not only from licensees, but also from staff. And I've done a couple of the audits myself, and it's been ambiguous. And my understanding was that was sort of intentional. But yeah, we could stand to have some clarification on maybe what would be considered directly related versus indirectly related. As a policy decision, the practice when doing the audits has always been to give the licensee an opportunity to sort of make an argument for why something might be considered directly related, and to go from there. But it might be better to have a more rigid definition as opposed to a case-by-case analysis. Yeah.
Well, I know the legislature has brought this up at the last the sunset hearing that I was at with a different board. They were commenting on the courses that were accepted by, I believe, one of the nursing boards, and the clarity and the prescriptiveness and all that. It is weird to have something at the end and something at the beginning, I guess, both.
I think it belongs more toward the beginning, like Austin originally suggested, but that's just me. And I say this because I maintain licenses in well, now I guess just one other state, but I'm constantly going there and saying like, okay, what do I need to do for this state? And I'm looking at their law, and it's sometimes difficult to find what I need. And I just think having it up front, like what do my courses need to cover? Having it at the top is better. But that,
Yeah. And it is also an option to move G up to the top with B as well and have them both at the top.
That's what I think we should do.
Okay.
Okay,
Okay.
just for a second, please, DP wants to have a comment. I would like to have a comment. Sorry.
I actually came to make the same comment that we could suggest moving G up. And then Austin and I had discussed in subsection D, there is the first sentence talking about at least a minimum of 1/2 of the unit shall be directly related, which may include, and then it gives several examples, models, theories, or frameworks that relate to client-patient care, et cetera. The sentence ends, and then it says other activities may include, but are not limited to, occupation-based theory assessment, interview techniques, et cetera. Is your understanding that those are all examples of directly related activities that would count towards the 1/2 minimum of PDUs that are required under this subsection? Because we do have an opportunity to clean this up a little bit. And we could move subsection G, and we could, if those other activities are also directly related, I would suggest that we could enumerate all of those in a single sentence rather than breaking them out into other activities. It feels a little unclear as written, just for your consideration.
Or is it to be understood that other activities may include, is that intended to be not directly related? I don't know if that was
Which would be more confusing to be under subsection G.
My understanding of it is that all the activities could be in one list because they are all, because G says of the total number of PDUs required for each renewal period, a minimum of 1/2 units shall be directly related to the delivery of occupational therapy services, which it may include blah, blah, blah. And then when the other activities talk about assessment, interview techniques, intervention strategies, and community environment as related to one's practice, those are directly related to the delivery of occupational therapy services. So they should all be, yeah, it's unclear why those are in two separate sentences.
So one option would be to first, all of the enumerated activities can be added to that first sentence in a grammatically correct manner. And then we could move subsection G up to, I would suggest putting it where B is right now, and or either having the option 1 from the last page of the proposed text being moved to where Austin suggested it initially, and then having what is currently subsection G moved to right after that option 1. So then you would have, at a minimum, you need 2 ethics, 1 PDU in jurisprudence, 1 in bias, and then a minimum of half of your required PDUs must be directly related, including but not limited to. Does that make sense? Okay.
I like it.
Okay. So then, Austin, if for later, if and when we do a motion on this, we should say as modified during the meeting, and we'll do it in that order.
Perfect.
Okay, thank you.
Thank you. Can I go to public comment?
Go ahead, Dana.
May I ask a question about a different section, not yet discussed? Because this was 10F as it's now edited. So a clarifying question first, please. Is the licensee gets their initial application and then their renewal comes on their birth date in the month of their birth, right? So this is what, because I think that this is something that I had brought to the board many years ago, and I feel very passionately about this one. So I am on the right page. Am I
I
right?
remember your advocacy for this.
Okay.
Saying
Thank
that
you for that.
It was a long time for someone, for a new grad to go without.
Right. Yes, because the people with the least amount of experience were going the longest treating patients without additional education. So this is within, I just want to make sure I'm reading correctly, probably the first renewal more than 1 year. So they are going to, wherever the birthday falls, at some point, they're not going to be able to go 3 years anymore. They're going to, somewhere in there, they're going to have that PDU period, 12 units, until they get into a regular ongoing lifetime cycle that requires the 24 PDUs in this item right here.
So this wouldn't make a change to when the renewal dates are assigned. That would still occur the same way that it is. However, if somebody's renewal, their first renewal after their initial license is less than 1 year away, or sorry, greater than 1 year away, then they would have to complete at least 12 units for that first renewal. However, as it's worded here, if that first renewal is less than 1 year, they still would not be required to complete any units. They would do their first renewal and then have 2 years to do the full 24 before their second renewal.
Thank you very much. That is exactly what I had wished and dreamed for, especially listening to people in the public, in the community. I'm just going to read some articles for my continuing education, and I'll just take a quick class. And I very much am very appreciative and grateful to the board for inclusion of this. The day has come. Thank you.
Thank you.
Thanks.
Well, and I'm just observing that since we're working on 4161B options for language, then those 12 units would be required to do 2 PDUs of ethics and healthcare, 1 PDU around laws and regulations, and 1 about culturally relevant practice as part of those 12. Probably then would have to incorporate that, but that would be good for a newly out of school occupational therapy practitioner. Yeah. So I would support having the same standard for those 12 as you would do for the 24 and future renewal periods. Not making any changes related to that.
And that was actually one of the changes that DP and I had discussed when coming up with or refining the option 1 and option 2. Previously, the language for B used to say, for a license renewed on or after January 1st, 2027, of the 24 PDUs required for each renewal period, licensees shall complete. We changed that to say just of the PDUs required to account for those shorter renewals where only 12 are required.
Well, I'd like to move to adopt the proposed regulatory language with the changes discussed at today's meeting, and option 4161B, option 1, and allow staff to make non-substantive changes.
Staff always appreciates the ability to make non-substantive changes. Thank you.
Good. Do we have a second?
Yes, I'll second.
Do we have any further board discussion? No? All right.
I just have a quick question. Do we need to include the standard language we have for that really long motion? Or is the motion sufficient for your needs? I do not know.
I will pull it up. One moment, please.
No problem.
Just a minute. I'm sorry, you guys.
We would just change that big mountain.
Drink from my bucket.
If the motion is sufficient as is, we can do that. Otherwise, we can see if Member Bookwalter would amend his order to include
I would.
the long paragraph and that the second would be amended to agree.
Okay. Do you want us to put it on the record? Yes. Thank you.
Okay. Oh, great. Okay. I would, do I need to withdraw? Just amend. I'd like to amend my motion as follows. I move the board approve the proposed regulatory text for sections 4161 as modified during today's meeting. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at section 4161 as modified and as noticed.
Is the second amended?
Yes.
Thank you.
Any further board discussion? No, do we have any public comment? Trisha, could we please open it up on WebEx for public comment?
Thank you. If any member of the public logged into WebEx would like to comment, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you. Yeah. Roll call. I mean, let's take a vote, please. I don't know.
Hunter Cabrera,
Yes.
Richard Bookwalter, yes. Christine Whitlisbach? We can't hear you.
Sorry. Yes.
Beata Marcos?
Yes. Motion carries. So, are you're not gonna present the language that you mentioned earlier? It was lost forever?
Thanks for coming back to me. It seems that there's enough difference according to the OT practice framework that the list should stay.
Okay.
It seems.
All righty. Well,
Thanks.
feel free to comment in the future. Sorry.
It's come to our attention that we need to do this for the one we voted on previously, 4130.
Okay.
Regs Council, do we need to amend the motion for the previous reg documents? Okay. So we can reopen that agenda item?
Where's that?
The one right before this one?
Like, wait, hold on.
Yeah, we need to revisit the item.
Okay, so we're gonna revisit the agenda item 20. Well, actually, are we moving on from the 21 altogether?
I believe we're done.
I just wanted for the record that this needs to be changed to 2025 on the memorandum for the strategic planning session in January of 2025 and discussion at the March meeting of 2025, not 2024.
So noted. Thank you.
Thank you so much. Now we're going to go back to agenda item 20, consideration and possible action to initiate the rulemaking package to amend California Code of Regulations, Title 16, Division 39, Article 4, Section 4130, fees. And we'll just amend our motion from before.
Yes, I'd like to amend the motion as follows. I move to approve the proposed regulatory text for section 4130 as discussed earlier at today's meeting. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at section 4130 of Division 39, Title 16. As noticed.
Do we remember who seconded that motion before?
It was
under item 20.
Christine?
I think I did. I think I did.
And do you go ahead and amend it now?
Yes, I do.
Okay.
All righty.
Board comment.
Do we have any further board discussion? See none. Do we have any public comments? Can we please open it up to public comment on WebEx?
Thank you. If any member of the public logged into WebEx would like to comment, please raise you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you so much, moderator. All right, moving on to agenda number.
We have to vote.
I'm sorry. Yeah, let's take a vote, please. Been a lot going on.
All right. Board Member Hector Cabrera, how do you vote?
Yes.
Christine Wittlisbach?
Yes.
Richard Bookwalter, yes. Beata Morcos?
Yes. Motion carries. All right. Agenda number 22, report on the board's 2025 action plan.
This item is mostly informational for the board members, but also for the public. And this follows the board strategic planning session that occurred in January of 2025, not 2024. Board staff has worked with DCA Solid to devise the strategic plan. And once that was approved by the board, staff further worked with them to develop this action plan, which is a more detailed and small steps implementation of the goals that were outlined in the strategic plan. So the strategic plan had 5 goal areas, those being licensing, enforcement, outreach and communication, laws and regulations, and organization and administration effectiveness. And those goal areas each had 2 to 5 objectives within them. That was the strategic plan. This action plan then takes those objectives and breaks them down into smaller tasks. So the goals and objectives are the same as previously approved by the board and discussed at the previous meeting. But if board has any questions regarding the specific steps that are here in the action plan, I'd be happy to answer those.
Do any board members have any comments regarding this or questions?
I think it looks good.
I agree.
I think this looks great, and at this moment, I would like to say a big thank you to Tricia Sinclair for helping us navigate through this and making it happen and helping our staff in putting it before us. So thank you so much for all your hard work. All right. So if there are no, do we have any public comments regarding this agenda item? Could we please open it up on WebEx for public comments?
Thank you. If any member of the public would like to comment on this agenda item, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you so much. Should we have a 10-minute break, or are we good?
Fine by me.
Do we need a little break?
Because
Because the legislation, the regulatory update on legislation might take a little time.
yeah, okay, if you want a break, yeah.
Can we just take a 10-minute break? But we'll be back at 12:15. All righty, welcome back. It's 12:17. Can we please reestablish the quorum?
Hector Cabrera, are you there?
Yes, I am.
Christine Wittlisbach, are you there?
Yes.
Richard Bookwalter, I'm here, and Beata Morcos?
Here, we have a quorum.
Thanks.
All righty, so we are gonna go back to agenda item 20, consideration and possible action to initiate a rulemaking package to amend California Code of Regulations, Title 16, Division 39, Article 4, Section 4130, fees. And we would like to once again amend our previous motion.
So I did the motion and Christine was the second. Is that
Yes.
right? Okay. So I'd like to amend the motion I made previously to agenda item 20 to read as follows. I move that the board approve the proposed regulatory text for section 4130 as provided in the materials and as amended during the meeting at subsection F to change the parenthetical at the end of the sentence from $210 to $300, and to direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at sections 4130 as noticed and amended, with the authority to make any technical or non-substantive changes.
I'll second that.
Any further board discussion? Any public comment? Could we please open it up to public comment on WebEx? Thank you.
Thank you. If any member of the public logged into WebEx would like to comment, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you. And let's take a vote.
We're calling the vote Hector Cabrera,
Yes.
Christine Wittlisbach,
Yes.
Richard Bookwalter, yes. Beata Morcos?
Yes, motion carries. And now we're going to go back to agenda item 21. Consideration and possible action to initiate a rulemaking package to amend California Code of Regulations, Title 16, Division 39, Article 7, Section 4161, continuing competency. And we would like to amend our motion as well, the motion.
And again, that was me and Christine, right?
Yes.
I would like to amend my motion for agenda item 21 on continuing competency as follows. I move that the board approve the proposed regulatory text for section 4161 as provided in the materials and as amended during the meeting to insert option 1 as a new subsection B and make amendments to option 1 language to move the phrase a minimum of from 1 up to B and move what is currently subsection F to a new subsection C and to direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at sections 4160 as noticed and amended, with the authority to make any technical or non-substantive changes.
I'll second that.
Thank you. Any further board discussion? Any public comment? Could we please open it up to public comment on WebEx?
Thank you. If any member of the public would like to comment, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you so much. Let's take a vote, please.
Calling the vote, Hector Cabrera,
Yes.
Christine Wittlisbach,
Yes.
Richard Bookwalter, yes. Beata Morcos?
Yes, motion carries. Good. All righty. Moving on to agenda item 23, regulatory update. Is that the one that you wanted to?
Yeah, I can.
So you wanted legislative?
I'll need your help on ledge after.
Okay.
Oh, regular. No, I don't want to do regulatory.
Okay,
I was
Austin.
thinking less. I'm sorry.
No, that's what I was asking. Thank you so much, Austin.
Thank you, President Marcos. So for agenda item 23, we have the regulatory update. This is a table giving the current status of the regulatory packages that the board has in process right now. At the last meeting, we gave an update regarding the package on the first page here to amend sections 4110, 4111, 4112, and 4114, having to deal with applications. That, while still not finally complete, has moved on since the last meeting. The decision from the Office of Administrative Law is actually due on Monday, and staff has been working with OAL representative to get this approved, and we hope to have that by Monday. So that should be moving on to the next stages very soon here and coming to fruition and going into effect. Following that, on the next page, we have a package. This package actually deals with some of the code sections that were discussed yesterday and earlier today. In particular, the advanced practices, hand therapy, physical agent modalities, and swallowing assessment, evaluation, or intervention, and 4161 down below that, continuing competency. So as I mentioned earlier when we were discussing 4161, we had to, if we're going to make additional changes to that code section, which the board voted to do today, we have to submit that as a separate package. So that code section will be pulled out of this package and will be submitted as its own. Similarly, the advanced practices section, 4151, 4152, and 4153 will be pulled out and included in another package, which we aim to present some language for at the next meeting once the practice committee has had the opportunity to discuss dysphagia. So that will be at the next meeting, and it will include the previously approved changes, very similarly to how 4161 was handled today. Following that, we have text approved by the board to make changes to the disciplinary guidelines and various enforcement codes. This has not yet been submitted to legal and budget for approval, but I do want to just mention to the board today that following some various changes in leadership at the board and some changes in Regs Council, it's a top priority for me to get started on this and work with DP to get this going through the process, because these are some much needed changes. And on the following page, we have some packages that have not yet been started. And we have the application renewal attestation. That is another one that we need to get started on and get text over to legal and budget. Similarly, for the supervision parameters, that one has been approved since November of 2024. So that's a package that we need to get moving as well. The physical agent modalities and application for approval in advanced practice areas falls under the changes being made to all the advanced practices areas. So that will be held until all three areas have been addressed. There is also a package that needs to be submitted for a method for OTs to request the ability from the board to supervise more than 3 OTAs. And that will be, it's waiting on discussion and review by the practice committee, as is patient record retention requirements. That is also waiting on discussion and review by the practice committee, which they will most likely be addressing either before the next meeting or the meeting following that. So we should see some movement on those soon as well. That concludes my update.
And thank you so much. Do any board members have any questions regarding this or any comments? No? Christine, Hector?
No.
Okay, thank you. Then we're moving on to agenda item 24, legislative update, and Mr. Bookwalter is going to be doing the update on that. Since he's our
Yeah, I just wanted to, maybe Austin would like to talk about the first one.
Sure.
Assembly Bill 1009.
course, thank you. So before we discuss the amended bills and new bills that are before the board for consideration, I did just want to give an update on Assembly Bill 1009, which the board had voted to support in its last meeting. So following the first material in this section, which is a table of bills before us today, immediately following that, you can see the letter that was submitted to Assembly Member Rubio and relevant parties in support of that bill, followed by just a confirmation that that was supported, or that was submitted rather. And we hope that the letter of support will help this bill in passing.
Yeah, the bill has passed the Senate on the 8th and was referred to I'm sorry, it passed the Assembly, it's in the Senate. It was referred to appropriations on the 11th, 2 days ago. So there's been some recent movement on that in the Senate to appropriations. I did a check this morning on the Legislative Info website to see what the status of some of these bills were. Most of these were just pretty much watches, except for all the other bills here were watches, or maybe even ones that we hadn't seen before, but that came through. So we'll just go through them one by one. AB 2277, the hearing was canceled on behalf of the author. This is having to do with behavioral health background checks. We were just watching that. AB 346, in-home supportive services, licensed healthcare professional certification, has to do with the definition of let's see, certification. Yeah, so it's specification of using the different professionals who can attest to a person's ADL needs for in-home supportive services. That passed the Assembly on the 3rd of June and went to the Senate on June 4th. So that's an update of that one. We're still watching that one. And if any board member wants to change a position or talk about positions, then, feel free to pipe in. It doesn't have a direct. That one I was wondering if we wanted to support. We could support it. We could go from watch to support, but we've been watching it. So it does include occupational therapy. As occupational therapist could be attest to in-home supportive service needs that people might have under this.
And AB 348 has been amended since the board last.
346. I'm still talking about 346.
Oh, my mistake. That one also has been amended since the board last looked at it. If that might warrant discussion of a position change.
I just checked on it this morning. Did you check on it this morning?
I didn't. Let's see. Let me look back. I have the website in front of me. AB 346. Yeah, the original language included occupational therapists as one of the parties who could certify for recipients of in-home supportive services. And then they just kind of moved it around. It says licensed healthcare professional includes, but is not limited to a physician, physician assistant, regional center clinician or clinician supervisor, occupational therapist, physical therapist, psychiatrist, psychologist, optometrist, ophthalmologist, public health nurse, or nurse practitioner. That really doesn't change a lot from the previous version of the bill in this one. It's just they moved it around a little. They changed some of the language about how licensed healthcare professional is described. I mean, Yeah, we could just we should just continue to watch it, I think. Unless, yeah. 348. Let's see. 348 has to do with the mental, let's see. This is about mental health full service partnerships. We were watching it. We could drop it. It doesn't really seem to very relevant. It's about Medi-Cal contractual obligations and eligibility for behavioral health clinicians. So unless you really want to keep track of behavioral health, it doesn't really mention occupational therapy. So we could drop it, stop watching it if you want, or we could continue to watch it. What do board members think? It passed the Committee on Health on yesterday in the Senate.
In my opinion, if OTs are not part of it, we can just drop it, but I can go either way.
Any opinions?
I think we should continue to watch it, given that, right now, my experiences in the last year, mental health is very much a important part, I think, of just about anything that anyone does, whether you're an occupational therapist. There's a lot of need to be on top of this. I'm in favor of keeping watch on this. I just see too much mental health problems, issues, and so forth and so on. I think we should.
Okay.
Yeah.
We can keep watching it. Sounds good. So we'll move on to 479. Are we ready to move on to Bill 479? It looks like this was, the hearing was canceled in March at the request of the author. So it doesn't seem like it's progressing. This has to do with people who are, it does have to do with a petitioner holding a license as a mitigating circumstance if there's some kind of issue with the license if they were a victim of intimate partner violence. So it would affect the board if it proceeds, but it's
likely won't.
But it likely won't. We should probably watch it just to see if it moves later on, because it would affect board operations. And 485 also requires state agencies, including boards and bureaus, to deny a new license or permit or the renewal of an existing license that's for employers. It would affect certain or applicable boards and bureaus. It passed the Assembly in June 3rd and was referred by the Senate to I think the Rules Committee. So it's proceeding. So we could just keep watching that, see if it's going to affect us. It may not. 489 passed the Assembly, was referred by the Senate to the 3 different committees: Business and Professions, Economic Development, and Judicial. And this has to do with artificial intelligence in healthcare professions. Would prohibit the use of AI technology, in that it would create some new potential regulatory activity. We probably should keep watching that. We might need regulations to enact that if it goes through, depending how it comes out. 667 passed the Assembly on June 4th, and the Senate has sent it to the Rules Committee. This is the one that requires boards to assist applicants who cannot read, write, or speak English by providing an interpreter. This is an interesting question because we use the NBCOT exam. Would the board then be asked to pay for an interpreter for the NBCOT exam with this? I don't know what provisions NBCOT has for providing interpretation for the exam. I don't know if it doesn't seem to specify in the current version whether the exam is the board's exam or the exam the board. It says the referred to in statutes, exams referred to in statutes. So the wording to me seemed to think that that this could affect the NBCOT exam because that's referred to. I believe the NBCOT exam is referred to in statute. In our statute is the exam. So this one might warrant some discussion and maybe a staff question to NBCOT about what type of interpretation services they provide as part of the exam taking process.
Absolutely.
Also, this includes, is there a fee for using an interpreter with an exam that NBCOT imposes that then might have to we'd be subject to as a board? So I had some concerns about AB 667 and how that might affect this board.
I'm going to double check, but the last time I looked, it was for board specific exams, not necessarily national exams, because while we contract, we don't necessarily have control over that. But yes, if this bill were to pass, it would be on the board to pay for those translators.
Yeah.
So we wouldn't have to provide a translator, but we would have to cover the cost of an applicant using one through NBCOT if it passed.
I'm going to check I'm going to check right now to see if it was changed or updated from the last analysis that I was given to see if it applied to contractual. If it does not apply to contractual, it does not apply to us. If it does, then we are required to pay for the interpreter. So we would likely have to contract for an interpreter. If we had a test that was board specific, then we would have to pay for the interpreter.
Gotcha. Yeah, they did say state administered and contracted, and they crossed out and contracted in the version that we have in our packet.
But our board doesn't do any testing.
We have a nationwide test, don't we? Don't we have?
Yeah.
Well,
It's
a licensing exam.
Well, one of the versions of the law just said, or referred to in statute. And I think that's where they got the contract. That was an earlier version of the bill. Now I'm looking at today's, I didn't actually read the whole bill this morning.
I see where or contracted license examination is crossed out, the or contracted. So this would be a board specific. So some boards have licensing exams that they themselves create. And in fact, when we were talking about the options at the last meeting for what we do with a review of the laws and regs, one of the options was that we create an exam. Well, that would be our own personal exam. And then if this were to pass, we'd have to pay for translators for that exam. So or contracted are the national exams or otherwise we contract out for somebody else to handle the exams. This bill would not currently apply to that.
Okay.
And it does look like that exam. And yeah, so it's no longer gonna be affected. They took that out because, okay.
Okay, so it's not affecting us.
Yes, but we should definitely keep watching to see what's going on. It'll affect us in the license applications because we'll have to hire interpreters for license applications, as will all the boards. So there'll be a DCA. They'll be working things out if this passes, because all the boards will be in the same boat with that. So we should definitely stay on top of what's going on with AB 667. Moving on to AB 742, that has to do with the process for expedited licensing for persons who are descendants of enslaved people. It passed the Assembly. It's in the Senate, going to the Rules Committee. So I think we should keep watching that. The bill's changed somewhat from last year. I thought it was interesting because they've identified a a bureau for descendants of American slavery as a potential source of information to help identify those potential license applicants. So let's see how that develops. AB 951 passed the Assembly, went to Senate Health. There's no change from what's in the packet. And that's about requiring rediagnosis of autism by some health plans in order to proceed with services. And we were watching that. AB, any questions so far about any of these bills so far? No? Board members? 1386 had to do with perinatal services, adding perinatal services to services that are required for certain facilities. I think OT is in the bill just as, but it's in the existing language, and that's nothing about this would affect the language around OT. We could probably drop this one because it doesn't really have a lot to do with the operable section of the bill is about adding perinatal services to a complex of services, and OT just happens to be elsewhere in the bill. So I think we could probably drop that one if you guys are okay with that. SB 740, I'm sorry, 470. I'm getting things reversed. Oh, that's the Bagley-Keene Open Meeting Act. Assembly Committee on, it's in the Assembly Committee, passed the Senate on June 2nd. It's in the Assembly Committee on Governmental Organization, extending the provisions of the Open Meetings Act until January 1st, 2030, that allows us to do, that regulates how we do these meetings like today. We were watching it. Do we want to, we could, I don't know if you want to support it, but we've been watching this because it would extend our ability to have some, at least semi-remote meetings through 2030. Or we could just wait and see what happens.
Is there a problem with supporting it? He gives us more flexibility, right?
Yeah, it'll extend it for another, until, it's scheduled to sunset, and then this extends it for another, until 2030.
Let's just do teleconferencing for 4 more years and still be in compliance with Bagley-Keene.
I will state that there are comments that have been submitted that are requesting more hybrid type situations similar to what we had for COVID, as opposed to having quorum in person, et cetera, while noticing locations for when we don't have quorum, which is one of the reasons they changed this from a permanent to let's just see how it goes for another couple of years.
I'm looking at the Senate analysis, which is online, just to see if who's maybe supporting. Okay, so support is, there's a whole list of supporters and a whole list of opposition. So support verified as of April 28th was all AARP, Alzheimer's Association, Alzheimer's Greater Los Angeles, Alzheimer's Orange County, Alzheimer's San Diego, the Association of California State Employees with Disabilities, the Association of Regional Center Agencies, California Association of Licensed Investigators, California Coalition of Family Caregiving, California Commission on Aging, California Foundation for Independent Living Centers, California Long-Term Care Ombudsman Association, Disability Rights California, DMS Registered Service Agency Advisory Committee, Easter Seals, Northern California, Family Caregiver Alliance, Leading Age California, Little Hoover Commission, and the State Council on Developmental Disabilities. In opposition, and again, they don't tell you why, were ACLU, California Action, California Broadcasters Association, California Chamber of Commerce, California Common Cause, California News Publishers Association, the CCNMA, Latino Journalists of California, First Amendment Coalition, Freedom of the Press Foundation, Howard Jarvis Taxpayers Association, League of Women Voters, Media Guild of the West, National, you want me to keep going?
No.
National Press Photographers, Orange County Press Club, Pacific Media Workers Guild, Radio, Television, Digital and the Society of Professional Journalists, Northern California chapter. Sorry.
We can just watch it for now, and then we can support it next time we have a meeting in September. So this way we have a better idea. Maybe they'll, as Helen said, maybe they can add things or make it more clear or whatnot.
Yeah, let's just watch it for now. I don't feel comfortable supporting it just
Okay.
yet.
Okay.
So we're kind of approaching the lunch thing.
So we got to go. We got to finish up. And I'm sorry to read a long list so close to lunchtime. Okay, 641 Ashby has passed the Senate on the 3rd. This is an urgency clause was adopted, and it's now an Assembly B&P, and it authorizes boards to facilitate their activities for people in a state, local emergency disaster area. Wages, we continue to watch that because it will affect us. Wages, behavioral health, medical surgical employees, that was with order to the inactive file at the request of the author. So it could probably, that's not going to go anywhere. 66, so that's then, and then the last one we should drop because it's that was a placeholder bill that had occupational therapy, had to do with occupational therapy. It now doesn't have anything to do with occupational therapy. It's a totally different topic about AI. So we can drop that one.
All righty.
That concludes my report on the status of those bills.
Thank you so much, Richard. I truly appreciate your help on that. You're really great at that. So at this moment, I would like to go to, is there any board discussion regarding this? No, I would like to go to open public comment on both agenda item 23 and 24, regulatory update and legislative update, since I forgot to go to public comment earlier. Do we have any public comment regarding agenda item 23 or 24? Trisha, could we please open it up on WebEx?
Thank you. If any member of the public would like to comment on agenda item 23 or 24, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you so much. We're moving on to agenda item 25, Executive Officer's Report. Go ahead, Dustin. Thank you.
Thank you. In the interest of time, I might go through this a little bit quickly, but if any of the members of the board have questions at any point, feel free to stop me. Beginning here, we just have an administrative update, which covers budget, personnel, and technology. So you can see at the top here, the year-to-date revenue earned by the board compared to year-to-date expenditures plus encumbrances, followed by a quick summary of our fund condition. We currently have 4.6 months in reserve. However, as discussed earlier when we were going over fee increases, this is downward trending and there's an imbalance there that still needs to be addressed. Expenditures based on fiscal month 10, which the budget office did touch on briefly. Just wanted to point out that while current projections show a safe level of spending, there may be some expenses that haven't been accounted for yet, and I'm continuing to work with the budget office to identify further savings so that we can make sure that we don't overspend. Personnel update, I was appointed as the board's executive officer on May 23rd, 2025, so that has changed. Since then, since the previous meeting, we have seen the departure of 2 members of staff, one in the enforcement and one in the licensing division. So at present, we have 3 vacancies, those 2 positions, as well as my previous position. We've also extended one of our retired annuitant positions. And then moving on to technology, still in effect, as discussed previously, is the 1-year deferral on renewal fees for licensees affected by the LA fires. DCA has also implemented a new citation withdrawn compliance code, which is going to help us and DCA more accurately track the amount of dollars of citations withdrawn. And lastly, the board has successfully replaced its pocket card printer. So some of the licensees out there may have had some issues ordering a pocket license over the last 8 to 9 months, and that has been resolved. We've caught up on all the ones that were in the backlog, and that option is back on the Breeze website for you to order. Following that, we have just more detailed description of the revenue report. Following that, we have a detailed breakdown of the board's expenditures. And again, these total out to the same numbers that were in the administrative summary. Followed by the fund condition and a more detailed breakdown of those technology updates. Then we have applications data for the previous quarter, January 1st through March 31st. So you can see a breakdown of the applications and the workload experienced by the licensing division. And then we have enforcement data. So we have a breakdown here of our total complaints, which ones have been open and referred to investigation, which ones have been to DOI, which ones have been transmitted to the Attorney General, and so forth. Then we have a breakdown of fines assessed for occupational therapists. You can see here that total fines is $30,456 for just that quarter. And then the occupational therapy assistant fines breakdown, which totals a little bit less, $15,655. And then we have the total number of cases pending with the Attorney General, a list of licensees currently on probation, and final decisions in effect for the previous quarter. And that concludes the executive officer's report, speedrun edition.
Do any board members have any comments or questions towards Austin and his report? I hear none. Do we have any further board discussion regarding this? Do we have any public comment? Can we please open it up to the public comment on WebEx?
Thank you. If any member of the public would like to comment, please raise your hand. We'll give you a moment. All right, I see no raised hands. Madam President, I return the floor back to you.
Thank you so much, Tricia. Thank you so much for your report, and thank you for speeding it up. We're moving on to agenda number 26, suggestions for future agenda items. Do we have any suggestions?
And if there are no suggestions at this time, this is always something that the president and I can work out as we prepare for the next meeting as well. But if there are any suggestions, we're happy to hear them.
Oh, do we have any public comment or suggestions? Can we open it up on WebEx, please, for public comment?
Thank you. If any member of the public on WebEx would like to make a suggestion for future agenda items, please raise your hand. We'll give you a moment. All right, I see no requests for comment. Madam President, I return the floor back to you.
Thank you so much. So at this moment, I would like to thank DCA for hosting us. I would like to thank DP for all your help and being here and helping Austin through this long process. I'd like to say thank you to Samia and OTAC for your support. Of course, Ada, you're amazing. Thank you so much for being here. Definitely our legal, Helen, you're amazing for, with all your help, and you're here to keep us on track. Thank you so much for your hard work. All of our staff, Jody, Karina, Bryce for helping with the camera and everything. And definitely to our moderator, Tricia, thank you so much for all your help. And to my fabulous board members for taking the time and making this meeting successful. Thank you so much and have a wonderful weekend. And we adjourn at 12:57.